Exam Scholar, Real Estate Edition.
Question 1. Many real estate contracts are in writing on forms. Parts of these contracts are written and parts are printed. In the interpretation of such contracts, A. Printed parts take preference over the written parts. B. The written parts and the printed parts are given equal consideration. C. The written parts take preference over the printed parts. D. Any parts copied from the form take preference over those that are purely original. Answer: C. As regards to contracts, the written takes preference over the printed parts and oral agreements take preference only when the written contract is incomplete or ambiguous. Question 2. A lender possessing a chattel mortgage may A. Assess it. B. Hypothecate it. C. Alienate it. D. All of the above. Answer: D. A chattel mortgage is a mortgage secured by personal property. Such a mortgage may be used as security for an additional loan. When the property is put up as security for a loan and one retains possession, it is said to be hypothecated. Personal property may be assessed for personal property taxes and/or federal estate taxes. Question 3. A real estate broker is usually A. A fiduciary to a person interested in buying a property the broker has listed. B. An attorney in fact. C. An agent serving the principal under a duly executed power of attorney. D. None of the above. Answer: D. The broker is usually the agent, fiduciary, of the seller and usually does not have a power of attorney. Question 4. When a broker shows a client's property to a prospective buyer that is listed with the broker under an open listing, the broker should A. Make up an office memorandum. B. Confirm the showing to the buyer. C. Notify the seller as to the prospect's identity. D. Notify the local real estate board. Answer: C. Notifying the seller establishes the broker's right to collect a commission as procuring cause. Notifying the seller as to the prospect's identity provides the only effective way of establishing that right. Question 5. Concerning business opportunities. A. The bulk sales law is contained in the Uniform Commercial Code. B. A bill of sale is used to convey title to business items. C. Sales tax is a tax on the sale of tangible personal property. D. All are true statements. Answer: D. All of these statements are true. Question 6. A licensed real estate broker working under a typical exclusive listing incurs several expenses. He is not entitled to be reimbursed for these expenditures, unless A. The buyer has demanded that these expenses be incurred as a condition of continuing with the transaction. B. Such expenditures were authorized by the principal. C. It was necessary for him to incur the expenses in order to close the sale. D. The broker was representing the best interests of the principal in consummating the sale. Answer: B. A seller is not obligated to reimburse the expenses of the broker unless those expenses are authorized by the seller. Question 7. A primary justification for zoning ordinances is to A. Maintain conformity to buildings in the zoned area. B. Prevent an oversupply of certain types of businesses. C. Promote public health, safety, morals and general welfare. D. Control the quality of building construction. Answer. C. Zoning laws are the exercise of police powers which are for the public health, safety, morals and general welfare. No compensation need be paid in exercise of police power, as they are for public protection. Question 8. A salesperson receives a deposit together with a written offer to purchase and delivers them to the employing broker, who presents it to the seller. The seller signs and accepts the offer. Without the consent of the salesperson and through no fault of his own, the buyer and seller instruct the salesperson's employing broker to return the deposit. Which of the following is true? A. The salesperson's employing broker may retain 1/2 of the deposit and must give 1/2 to the seller. B. The broker may sue the seller but must return the deposit. C. The broker may retain 1/2 of the deposit and must return only 1/2 to the buyer. D. The broker may retain the deposit to compensate him for his efforts. Answer. B. Once the offer has been accepted, the deposit money belongs to the seller. If the seller instructs the broker to return the deposit, the broker must do so. The broker has probably earned a commission and may sue the seller for the amount but may not hold the deposit money. Question 9. An attorney drew up a contract between a buyer and a seller for the purchase of a property. The agreement included a liquidated damages clause calling for the payment of $500 in the event the buyer should default. Prior to the close of escrow, the buyer decided that the home would not suit his family and canceled the purchase. If the seller were to sue for specific performance, he would most likely be A. Successful because the $500 is not adequate considering the value of the property. B. Successful because the reason for canceling by the buyer was not strong. C. Unsuccessful because the seller agreed to accept the $500 as liquidated damages in the contract. D. Unsuccessful because an attorney drew up the contract. Answer. C. Since both buyer and seller agreed to the liquidated damages, the seller has agreed that if the buyer defaults, then his sole claim will be to the $500 only. Question 10. A second offer received on a property prior to the seller's decision on the first offer should be A. Evaluated by the broker against the first offer. B. Submitted immediately. C. Held pending a decision on the first offer. D. Turned back to the offer if it doesn't provide better terms. Answer. B. All offers must be submitted immediately.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. If an asset is showing a decline in monetary value or a decline in the value of property, this is best known as A. Depreciation. B. Expense. C. Declining value. D. Comparable dispersion. Answer. A. Depreciation is a decline in the value of property and, in accounting, is the declining value of an asset. Question 2. In the most basic sense, debt is considered A. Any amount owed to another. B. A credit from one person to another. C. An owed amount with interest. D. Anything of value that is borrowed from another. Answer. A. An amount that is owed to another is probably the simplest form of the definition of debt. Question 3. A loan in which the lender makes payments to the builder at periodic intervals as the work progresses is best called A. A short-term interim loan. B. A construction term loan. C. A convertible construction loan. D. A periodic convertible loan. Answer. A. A short-term interim loan is a loan in which a lender makes payments to the builder at periodic intervals as the work progresses. This type of loan is also known as a construction loan, but not called a construction term loan. Question 4. Homeowners association fees are also sometimes called A. Common area assessments. B. Condominium fees. C. Common designated conveyances. D. Area commune fees. Answer. A. Homeowners association fees are also sometimes called common area assessments. They are paid by the individual owners and are used to maintain the property or common areas. Question 5. A time deposit that is held in a bank that pays a certain predetermined amount of interest to the depositor is known as A. A certified deposit. B. A certificate of deposit. C. An interest-bearing account. D. A time-stamped deposit. Answer. B. A time deposit that is held in a bank that pays a certain predetermined amount of interest to the original depositor is called a certificate of deposit. Question 6. If a homeowner refinances the mortgage on the property at a higher amount than the current loan balance for personal use, this is called A. Cash-out refinance. B. Reverse mortgage. C. Equity line of cash. D. None of these. Answer. A. A cash-out refinance is when a homeowner refinances the mortgage on the property at a higher amount than the current loan. This happens when the current borrower intends to use the money for personal use. Question 7. The final lump sum payment due at the termination of a specific type of mortgage is best called A. A hovering payment. B. A balloon payment. C. A floating payment. D. A deferred payment. Answer. B. A balloon payment is a lump sum payment that is due at the termination of a balloon mortgage. Question 8. The best definition of an appraiser is A. An individual qualified by education and experience to estimate the value of real and personal property. B. An individual that works for lenders exclusively to estimate the value of real and personal property. C. An individual that works exclusively independently as a contracted agent to estimate the value of real and personal property. D. None of these. Answer. A. An appraiser can work for lenders or they can work as independent entities. They are always qualified by education and experience to determine the value of real and personal property. Question 9. A value created according to a government formula intended to reflect the true annual cost of borrowing expressed as a percentage is called A. PR. B. ARP. C. CPR. D. ADR. Answer. A. Annual percentage rate, otherwise known as APR, is a value created according to a government formula intended to reflect the true annual cost of borrowing expressed as a percentage. Question 10. Liabilities, including long-term and short-term debt and any amounts owed to others, is best known as a person's A. Financial obligations. B. Net worth minus expenses. C. Debt. D. Assets. Answer A. A person's liabilities that include long-term and short-term debt as well as amounts owed to others is best called their financial obligations. Question 1. Land is typically appraised by what approach? A. Income approach. B. Gross rent multiplier approach. C. Option approach. D. Market data approach. Answer D. Land is typically appraised by the market data approach by comparing the subject property to recent sales data of comparable parcels of land. Question 2. If Sarah Jean recently begins to receive her own tax bill after purchasing her property, this means she has most likely purchased into A. A condominium. B. A lease. C. A tenancy in common. D. A syndicate. Answer A. A condominium is owned in fee simple, just as a normal home would be. This means that the homeowner, or condo owner, receives his or her own property tax bill. Question 3. Which party is most likely to sue for specific performance in regard to the purchase of real estate? A. The buyer. B. The seller. C. The broker. D. The attorney of the brokerage. Answer A. The party most likely to sue for specific performance would be the buyer. This is done by the buyer to force the seller to sell. Question 4. When are mills most often used? A. In the calculation of square inches. B. In the appraisal of the property. C. In the assessment of the county fire code. D. In the assessment of property taxes. Answer D. Mills, each 1/10 of a cent, are sometimes used to express the tax rate per dollar of assessed value. Question 5. What is the difference between market value of a property and the debt on the property including all liens? A. Income ratio. B. Assessed value. C. Equity. D. Market fluctuated value. Answer C. Equity is the difference between the market value and the debt on the property. Question 6. The first step of a jurisdiction attempting to enact eminent domain is to A. Attempt to purchase the property in question. B. Give the owners a 30-day notice to vacate. C. Seek an injunction. D. Obtain a writ of closure. Answer A. The first step of the jurisdiction would be to attempt to purchase the property at a fair market rate. Question 7. If the buyer, Sue, gives her agent, Jesse, an envelope of cash to hold as her earnest money for the property she wishes to buy, she is trusting that Jesse will protect this money for her and is an example of the fiduciary duty of A. Due process. B. Accounting. C. Competence. D. Escrow. Answer B. This is the fiduciary duty of accounting. The agent must be able to hold and produce anything that is given to their care. Question 8. If a contract has a clause that states time is of the essence and either party fails to act in a timely manner to execute the contract, they can be held in A. Breach. B. Default. C. Void. D. Non-performance. Answer B. If any party fails to take care of their matters in a timely manner in this situation could be held in default of contract. Question 9. In an area neighborhood that has a home in a dilapidated state that would require extensive remodeling to be compared to other homes in the area, what would this be an example of? A. Depreciation. B. Incurable depreciation. C. Curable depreciation. D. None of these. Answer. B. This is an external factor caused by the other homes in the area. This is a form of incurable depreciation. Question 10. The civil penalty for a first violation of the federal fair housing laws can be as much as A. $1,000. B. $5,000. C. $10,000. D. $50,000. Answer. D. The court may assess civil penalties against the violator up to $50,000 for a first violation and up to $100,000 for any subsequent violation. Question 1. How many sections are in a township? A. 640. B. 280. C. 36. D. 20. Answer. C. There are 36 sections in a township. There are 640 acres in each section. Question 2. How many square feet are in an acre? A. 43,560. B. 23,040. C. 12,820. D. 64,640. Answer. A. There are 43,560 square feet in an acre. Question 3. When debts of a person are erased in bankruptcy, what is this called? A. Relinquish. B. Discharge. C. Closure. D. Erasure. Answer. B. The act of closing a bankruptcy case and releasing the principal from the debt is called discharge. Question 4. Financing costs usually rise on loans with A. Easy terms. B. Low down payment. C. Both of these. D. None of these. Answer. C. A loan with easy terms and low down payment must be secured, and this usually will raise financing costs. Question 5. If a neighborhood is only partially built and remains this way over a period of time, this could lead to A. Blighting. B. Negligence. C. Breach of contract. D. None of these. Answer. A. A blighted area means an area that, in its present condition and use, substantially impairs or arrests the sound growth of the municipality, retards the provision of housing accommodations, or constitutes an economic or social liability, and is a menace to the public health, safety, morals, or welfare. Question 6. The broker loan law states that the broker's loan statement must contain estimated costs including A. Escrow. B. Appraisal. C. Title. D. All of these. Answer. D. The broker's loan statement must include, among other things, estimated costs including escrow, title, appraisal, notary, recording, and credit investigations. Question 7. The possessor of land in which an easement crosses cannot A. Terminate the easement at will. B. Use the easement. C. Remain as dominant. D. None of these. Answer. A. An easement cannot be terminated at the will of the dominant property owner. Something of this nature must be determined by the courts. Question 8. A licensed real estate broker that specializes in property management usually acquires commission based on A. A percentage of the gross rents collected. B. The life of the leases. C. The value life of the property. D. A percentage of yearly estimated leases. Answer. A. A licensed real estate broker specializing in property management usually earns commission based on a percentage of the gross rents collected. Question 9. An interest in real property can be obtained by A. Court order. B. Prescription. C. Verbal agreement. D. Notarized documents. Answer. B. Typically, an easement is an interest in real property and it is acquired by prescription. Question 10. A deposit that is given to a broker from an interested buyer that has had all deposit receipt conditions fulfilled should be given to whom if the buyer decides to back out? A. The buyer. B. The seller. C. A neutral third party. D. None of these. Answer. B. If all the deposit receipt conditions have been fulfilled, the deposit belongs to the seller. Question 1. Which of the following items could not be used by the owner of a hardware store as security for a loan, under the provisions of the Uniform Commercial Code? A. A personal note endorsed by him. B. Accounts receivable. C. Stock for sale. D. Equipment and fixtures. Answer. C. As the stock will be sold, it cannot be used to secure a loan. Question 2. A valid escrow requires which of the following? A. Escrow instructions with no conditions. B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party. C. The services of a licensed real estate broker. D. None of the above. Answer.
B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party are required for a valid escrow.
Question 3. If the loan-to-value ratio is low. A. The equity in property is high. B. The equity is not affected. C. The equity in the property is low. D. None of the above. Answer. A. Loan-to-value ratio is the ratio of the loan to the appraised value. If a 90% loan-to-value ratio is given by a lender, that indicates a 10% down payment, and a beginning equity of 10%. If the loan-to-value ratio is only 60%, the down payment is 40% and the beginning equity is 40%. The lower the loan, the higher the equity. Question 4. Sellers are usually reluctant to cancel an existing transferable fire insurance policy in the event of a cash sale, due to the fact that A. A buyer may not properly cover the property. B. The higher short-term cancellation rate will apply. C. It could result in cancellation of other policies. D. The elimination of a cash return in the proration. Answer. B. A seller on a cash sale would be reluctant to cancel an existing transferable fire insurance policy because the seller would receive a short-term cancellation rate. Therefore, the seller would prefer to transfer the existing policy to the buyer. Question 5. A minority purchaser enters your office and states they are looking for, and interested in purchasing, a particular property in a minority neighborhood. You could legally assume that A. This person is testing you and your legal procedures. B. They are interested in that particular property. C. They are interested in owning a home in an all-minority neighborhood. D. They cannot qualify to own property in a higher-priced area. Answer. V. Should any prospective purchaser enter your office requesting to see a particular property, you would assume they were interested in that particular property. Question 6. A subdivider and developer purchased considerable acreage and now plans to construct a tract of 40 homes. In arranging the financing for the new construction, the lender has agreed to advance part of the funds immediately and will release a set amount of additional money as each home is completed. The funds that will be forthcoming as construction progresses are known as A. Obligatory advances. B. Reconveyance funds. C. Release monies. D. Open and mortgage payments. Answer. A. This type of construction financing is referred to as obligatory advances or fixed disbursement schedule. Question 7. All of the statements below are true, except A. A grant deed may convey after acquired title even when such warranty is not actually written into the contents of the deed. B. A quitclaim deed may convey any right or title including fee simple title. C. A deed is of no effect unless delivered. D. A reconveyance deed is used to convey title to a new purchaser in connection with a trust deed sale. Answer. D. A reconveyance deed is given by a trustee to the borrower, known as the trustor, after a loan has been paid in full. The borrower records his deed of reconveyance to clear the loan lien from the record. Question 8. Which of the following is not a necessary element in the formation of a contract? A. Offer. B. Acceptance. C. Consideration. D. Performance. Answer. D. Two parties may enter into a contract, but they might not fulfill, also known as perform, their obligations. Question 9. Lenders use the term debt-income ratio to refer to A. Part of closing costs. B. Loan qualifying tool. C. Requirement of the federal government. D. Formula used in appraising property. Answer. B. Debt-income ratio indicates the fraction that your loan payment on the property is in relation to the net income from the property. This is used by lenders when qualifying a person for an income property loan and measuring their margin of safety. Question 10. A prospective client calls you and asks you to take a listing on his property. In reviewing his papers, you discover he is purchasing the property on a contract of sale that has no acceleration clause, and that has no provision in the contract prohibiting a resale or an assignment. Which of the following is the most nearly correct statement? Your client could A. Sell his interest in the property, but only if he pays off the contract first. B. Sell or assign his rights but not his duties under the original contract unless the contract seller's approval was obtained. C. Properly give the purchaser a warranty deed to the property providing the deed recited subject to the existing contract of sale. D. Properly give the purchaser a grant deed to the property, providing he took back a recorded purchase money second trust deed to cover the payments due on the original contract of sale. Answer. B. A party purchasing property under a land contract of sale may sell their interest without difficulty by assigning the contract, provided there is no prohibition on the agreement. The assignee would still be secondarily liable for some of the terms of the contract unless the seller's approval was obtained.
Exam Scholar, Real Estate Edition.